Welcome to Employee Termination Tips. My name is Christopher Neufeld, Neufeld Legal. And in this particular video, we're going to be addressing payroll irregularities and underpayments and why most people need to wait until they're terminated or quit or fired from their job until they can effectively address these questions. Because the first thing is that payroll varies from jurisdiction to jurisdiction. What do I mean by jurisdictions? I mean from one state to another state, from one province to another province, from one country to another country. And simply because it seems like your payroll is being paid correctly. When we're talking about payroll, we're talking about overtime pay. We're also talking about vacation pay. We're talking about holiday pay. We're talking about regular wages. You might think it's being paid correctly. And it's very difficult to ascertain if it is. Because what we see, at least what I see in my professional estimation, looking at all this payroll stuff, is that yes, in certain jurisdictions, there's a baseline payroll which is correct. But in far too many other locations, other jurisdictions, especially places outside the United States, and when you look at it outside of major core jurisdictions from where the payroll software and the payroll trading emanates, there are serious issues with respect to payroll, and in turn, there is a serious prospect of underpayments. The big problem is that can you really challenge this while you're working for a company? And is it worth your while? Because when you start challenging your employer and you're telling your employer that they don't know what they're doing and that they owe you money, the problem is that if they owe you money, they probably owe everybody else money. And if you force them to pay you, they're going to be forced to pay everybody else. And if they don't pay everybody else and the word that's out there doing it correctly, they're going to be subject to lawsuits. So take a very hard position on that. And it's the lawyers, especially the lawyers who have been advising them in the beginning, all too often have told them what they're doing is correct or they don't really know what they're doing. But they say, we have ways to argue this. So if you challenge them while you're still working, what is going to happen? You're going to challenge your employer. And when it's time to let somebody go, when it's time to fire somebody, you know who they're going to be looking at? They're going to be looking at you. And that's the person they're going to let go first. Because that's just the way humans operate. And employers are no different. If you challenge them, you can be quickly out the door. So most people are not really in a position to fight with their employer and lose their job simply because they might or they might not be losing out on money that they're owed, that they've earned. So what instead you need to be doing? What you need to be doing is collecting the materials, understanding where your payroll is, getting the evidence, and when you finally leave the job, whether you quit the job, you depart on your own terms, you resign, you're fired, you're terminated, you're laid off, that's the time to challenge your employer, who's now your former employer. That's the time to go after your payroll. Because at that point, what you have to lose, you're not going to lose your job. You've already lost your job. Either you've given up your job or your boss is taking your job away from you. So when that comes about, well, then's the time to address your payroll. And it might be years from now that this happens. But you got to start collecting your materials. Start looking at the legislation that's specific to your jurisdiction. Look at your contract and making sure you're in the right. Because if you are, you could be owed a considerable amount of money. We're not talking about simply a couple $100. We're not even talking about oftentimes $1,000. We're talking about a potential of tens of thousands of dollars, even in excess of $100,000, $200,000 that could be owed to yourself. But so much of it depends upon the jurisdiction that you live in. And in particular in Canada, it depends on the province that you're employed in, how long you've been in there. Because in certain provinces, the law is designed to protect the employees. And the employees don't fully recognize this. The employees' lawyers don't fully recognize this. But fortunately, the government, whether it's the provincial government, even the federal government, in their wisdom, if you want to call it wisdom, or just out of pure luck, because nobody really pursues it properly, in my estimation, there's a considerable amount of money that's there. And instead of simply saying it's money that's owed, it's money that is earned, and it's money that's in trust, and the law says it's in trust. What does that mean? It means that money stays there and is not impacted by any statute of limitations or other limitation period. So depending on which province you are working in, such as the province of Alberta, you could have been working in a province arguably for 10 years and be underpaid $10,000, $20,000. I know it sounds like a lot. It sounds like crazy, but this is what happens when you actually follow the wrong laws, you follow the wrong payroll practices, you use the wrong payroll software. This is what happens. And when this happens, and you have laws that are in place that protects that earned money, year after year that money accumulates. And over time, $10,000 over 10 years. It's $100,000 that you've earned, and your employer, or now maybe your former employer, has been holding on to yourself. And the law very clearly states that the money is held in trust. That means that money has always been your money. It's never been the employer's money. The employer might have had it in its bank account. The employer might have used it for its own personal business expenses. And it might not technically be there anymore. Nevertheless, the law says it is your money. You have earned it, you're entitled to it, and you should be pursuing it. Actually, things are different in different provinces, different countries. I can't speak for everything. But this is how the law works. The law is very specific. The calculations are very specific. And the mistakes that are being made are far too common. And the costliness of them is far too grand to overlook. Because we don't operate in a uniform system where there is but one payroll software system. There is but one means of calculation. No, that is not how it works. Calculations are so specific to the jurisdictions. So specific in Canada to each of the provinces. And simply because it might fly in one province doesn't mean it flies in every other province. In fact, that's the biggest mistake that I see across Canada, is that they too easily think that because it works in one province, it should work in the other provinces. But the laws are different. Every province has its own employment standards legislation. And because of that, the laws result in different calculations. And simply because you have the same hourly rate, this is the base hourly rate, the net effect on your final earnings can be very different when it comes to overtime pay, when it comes to vacation pay, statutory holiday pay, termination pay, severance pay. All those pays different. Again, chart it out for you. In every province, the calculations are different. You have to understand how the calculations work. You have to understand what the statutory minimums are. And if you simply blindly follow what's being put out there by your employer, hey, that's your own problem. You can lose out on thousands, tens of thousands, even hundreds of thousands of dollars. That's your own fault. What I'm telling you is at least take the time, analyze the stuff. You can't analyze it necessarily when you're working. You can do a bit of the analysis, but you can't bring it to the fore. But what you should do, talk to the lawyers. Figure out the strategy. Because you need a strategy in place. You need the evidence to back you up. You need to understand where you stand. And typically, as I say at the beginning, you're going to have to wait almost until you're let go from your job. You lose your job. You leave your job. And you can pursue that money. But when that time comes, and it will come, unfortunately, that is when you need to be ready. That is when you have to get your money. And then you can't simply rely upon termination pay in lieu of notice and severance pay, because that might be calculated correctly, or it might be close to being calculated. Even if it's not calculated correctly, you know what's going to happen? Is, like I say, just take it and accept it. Because the problem is, severance pay portion, that's common law. That's case precedent. That's years in court. If you don't have anything else, if you have no other leverage to deal with. How do you get leverage? You get leverage by knowing where the payroll issues were, where they were inaccurate, where the company has consistently been underpaying its employees, where you've been underpaid, but not only you've been underpaid, but your fellow employees have been underpaid. And when you know that, and you have that available to yourself, that's when you have leverage. That's when you have negotiating ability, and that's when you can seek out the money that you're entitled to. Because all this money is entitled to because you've earned it. The law stipulates it. And especially when it's set out in employment standards legislation and it's statute. It's not simply arguable case law. We're talking about statute. Government made law as to what the statutory minimums are. And if they're not following it, that's a problem. And you need to pursue it because that's what you're entitled to and there's no questioning it. That is the law and that's how it's to be dealt with. And that is why you need to understand where you are from a payroll perspective. It's so important. And even though you might not be able to do anything about it necessarily right now, because it can jeopardize your current employment status, you need to be looking into it. You need to be prepping yourself because it's almost inevitable that one day you can be out of a job for whatever reason. And even if you quit your job, you resign your job, you leave your job, even then, you need to consider this beforehand. You need to collect the money that you've earned. Meanwhile, if you're fired or otherwise terminated or laid off from your job, there too, you need to have this available to yourself so you have the ability to negotiate with your former employer and not only seek the stuff that you're entitled to, which is based in common law in addition to statute, but you have the ability to draw upon employment standards legislation statutory minimums to get your full payroll that remains due and outstanding. And yes, things differ from jurisdiction to jurisdiction. But if your jurisdiction has this applicable and you're in the right position, you need to be pursuing this because it's your money, you've earned it, you're legally entitled to it, and it's yours, and you should be pursuing it. You'll probably need a very good lawyer to do it because naturally your former employer is not going to want to give it up. But it's your money, it's your entitlement. So look into it, and where you feel confident about it, pursue it because it is your money. Thank you.